Hi, everyone. Welcome to the 168th episode of the AfricanMusicLaw.com show. I'm your host, Miss Uduak. We do have some really interesting stories to cover, specifically looking at legal commentary and analysis. But before we get into all that stuff, let's really just set the tone for who we are, what we do, what we're all about, so you get to know. So if you're just joining us for the first time, welcome. Good to have you join us and our community, the African Music Law family and community. And what we do here is essentially empower the African artists being broader expansion to include all creative artists, frankly speaking, whether they can be found on the continent or in a diaspora, literally wherever they can be found. And we focus on doing so through several means, one of which is exclusive interviews, legal commentary and analysis, of course, top stories and news that we talk about as well. Periodically, we will have, of course, roundtable discussions, bring in industry experts and professionals to come talk about their experiences and insights to some of the latest topics and what's, the shifts and trends that are happening in the industry. For the most part of 2021, we've been doing a lot of inviting guests, having our roundtables, among other things. So at the tail end of this particular quarter, and preparing for 2022, we're going back to the core of the core competency that we offer and the essence of our brand, which is a lot of the legal commentary and analysis and some of the latest pop culture topics that intersect or collide with the law. And so I'll be guiding you today, talking to you about some really interesting stories I want to cover, both on the continent of Africa and certainly here in the US. Before we get going, let me just highlight a few things in terms of how to participate today. First of all, excuse me, feel free to leave your comments. And when you do, what will happen is it will show specifically, and it will allow me, you could see the scroll at the bottom of the screen. It will allow me to pull your comments in and get you participating as well. So please feel free to join me in that regards. For our newsletter, please feel free to sign up for our newsletter at africanmusiclaw.com, so that you can get our weekly newsletter. In addition, you can subscribe to the show, the podcast itself, on all major podcast streaming platforms. This show is particularly for the live stream. You are watching it either via YouTube, Facebook, for the most part, LinkedIn. Those are the three platforms we're streaming this particular episode. But for our podcast listeners, which is a major way we distribute our episodes, make sure that you, again, subscribe on all major streaming platforms, Amazon Music, Apple, Spotify, etc. You can find us there. Just simply type up African Music Law. And then for this particular episode, before we get started, let me give you a quick background on who I am and the importance of the legal commentary and analysis I'm giving today, and how that does not constitute attorney-client privilege. It's just general information. So I'm a California-based lawyer. I have been practicing for 20 years. My work includes both transactional and litigation work, and it's along the lines of the issues and things I cover for African Music Law, which is obviously a different brand and focused more on publishing and media-related activities, services, products, etc. So when I start talking about some of this latest pop culture topics that are intersecting with the law, it is obviously not legal advice specific to you. If you have a specific matter that you want to, consult with me on, feel free to hop on over to my law firm website, fashionentlaw.com, and I'm happy to talk to you about it. Simply just schedule a consultation. We can go from there. But for this particular purposes, this is simply for informational purposes. Again, I hope you will participate and invite others to do so. And of course, you can always watch the replay right after as well. Having said that, we're ready to start our first case that was quite interesting to me that I want to cover today. And that is the Reamer case versus DJ Neptune. Let me pull that information up just real fast. Give me 1 second. So you see who we are referring to today. And the issue involves the release by a DJ. So here we go with the visuals. And yet another visual is this. And the reason why this particular case is of interest to me is you've got an artist who is emerging, but really been recognized, Rima, been recognized on the global front. He is signed to a subsidiary of um, Maven Records, which is one of the probably said to be at this point the largest brand in terms of labels, in terms of what they're doing specific to Nigeria, and frankly speaking, what one could argue from the continent. So he's got a label behind him. He's an emerging artist. He was in 2019, President Obama had him, and I'm going to show this right here. So we're talking, for everyone just joining us, the Rima versus DJ Neptune for unauthorized release of his music. And who is Rima, shortly or briefly, he was signed to Maven Records, Jonesing World, which is a subsidiary of Maven Records. And in 2019 appeared on President Barack Obama's summer playlist. I mean, he's gotten a lot of traction, global recognition. One of his major hit songs is Do May Be. So you've probably heard of the song, who knows? But nonetheless, and notwithstanding, what was interesting about this case is it also actually ended up getting mainstream Western visibility. So this artist goes on social media and essentially calls out DJ Neptune, who's a fellow Nigerian, also on the continent, living in Nigeria, and has just dropped an album of his own. And specifically, Reamer says, you have a track of mine titled For You. You had absolutely no permission whatsoever to release that song. On the back end, you all tried to, make that work. It didn't happen. And I told you not to release the song. Notwithstanding that, you still moved ahead and released the song. So I'm going to give you notice right now. You need to take that down. He wasn't even as polite as I am being. He was very in your face, take my music down. My art is so important to me. And within the Nigerian culture and African culture as a whole, unlike the US culture, I would argue, respect is paramount and so huge. So he does sort of acknowledge a little bit of respect, call him bro or big bro or whatever. But notwithstanding that, he says, take my stuff down, effective immediately. Now, on the back end, so this creates a whole uproar, and of course his team on the management side step in, and also the other artists, the DJ Neptune's team step in as well. The lawyer has something to say on the DJ Neptune side. DJ Neptune's manager has something to say as well. And basically, I think I showed you all already, but let me show you that screen again, which is essentially this dialogue on the back end that I believe DJ Neptune's team shows to say, we had an ongoing dialogue about clearing the music. Our intentions were good. And somehow there was a miscommunication, allegedly. And so we went ahead and released the music. So hold on a sec. Let me give you that information again. So you see that whole dialogue back and forth. But here's the deal. And I'll also come in and sort of give my commentary on that. So I don't know why we're releasing music without everything completely being cleared. Here's what specifically Rima had to say. Don't violate the codes. Can't drop my song without my notice. Can't even remember the last time we spoke, big bro. I pleaded with my manager behind the scenes when y'all tagged me before it dropped, right? So going back to that whole big bro respect thing I was talking about, and him saying, look, I already gave you guys notice prior to, do not drop my song, clear it. If it's not working out on the clearance side, keep it moving, kind of thing. And then what happened is one of the OAPs, on-air presenters, as they're called in Nigeria, stepped in and said, hey, it's none of our business in terms of the public and social media, what you did behind closed doors in trying to broker your deal. So guess what? Take it back behind closed doors and deal with it and resolve it. You don't need to be on social media about that. So this was Rima's response to that. He says, I didn't record it together. Neither was I paid. Neither did I sign any documents. Neither did the producer ask for my consent. before releasing my stamp. So clearly he's very, very upset, and understandably so. There should be no reason why this should be happening. The other question I'm going to ask you all, and certainly please feel free to leave your comments. I'll again bring it in here so that we can talk some more about it. Is anyway, what ended up happening is one of the manager on the part of Rima steps in and says, since an official approval was not released nor split sheets signed, I felt the song wouldn't be released anymore. That's Sean Okeke that said that. So I also saw some screen capture by the attorney trying to exonerate his client publicly. The only thing I didn't see, there was a back and forth conversation, and the attorney then releases documentation showing that at the tail end of it, he forwarded the final clearance documents. What he did not show, though, is that there was an actual meeting of the minds, an actual agreement, and a signing of that document for that release. So until that happens, and barring a showing of that evidence, at no point should that song have been released. So Rima is right based on his viewpoint that, look, even if we were in negotiations is not the final thing, and you didn't have the final approval to release that song. So several things just backing up here. First of all, on the legal side, I don't see any basis for an attorney, my own perspective, to be releasing documents back and forth of whatever negotiations on the back end that you had with your client and the other side, and whatever that outcome is. It's absolutely unnecessary. Either put an official press statement out there through the client, since they're more on the visibility side, or PR company, or you could even do it directly through your firm. But there's no reason to be releasing the back and forth email correspondences, and also down to the documentation that was signed. Nigerians and Africans as a whole, there's a tendency to sometimes want to really, really take things to the court of public opinion. It's none of the public opinion's business, or the public's business, on how you're transacting private transactional matters with respect to your clientele. You have someone on the other side saying you never got clearance. You could put a statement out to say, no, we did get clearance, and we're sorry that there might have been some sort of misunderstanding, et cetera, and sort that issue and clean it up. But at no point should you be putting documents out of what you're working on. Whose business is it? And I know that different jurisdictions do things differently, but here, if you did that, that would be a problem. So please be mindful of that, especially for the emerging attorneys over there. I know a lot of you are still, entertainment law is not relatively new to you, and things are done differently, but that's not a good way to try to resolve an issue, in my opinion. Anyway, ultimately, you did have, like I said, the Rima's manager that said there was never an actual clearance about this. So if there was never an actual clearance, my understanding was things would not move forward and there would be no release. Well, right now, it appears the last update on that, DJ Neptune and Rima have been able to resolve their issues and have decided that they're going to move forward with working together potentially in future. But as to this one, they've resolved that issue for the For You track. So lesson of the day, get your clearances, get your split sheet signed, get whatever agreement signed. And if you don't have that, please do not move forward unless you have that permission, because if you don't, you're going to have situations like this alleging copyright infringement. And that's just before the actual filing of a suit. Worst case scenario, they can wait for you to do all that, all the money comes in, and then you get hit with the lawsuit and have to deal with the accounting and have to deal with an injunction, which you certainly do not want. So that is that topic that we are going to wrap it up with. So let's move to the next one. The next one I want to talk about is Davido entering the cryptocurrency world with his eChoke social token. I think it's very exciting times right now in the digital space and all the things that are happening. Let me show you that announcement that Davido made online via Instagram with respect to his eChoke token. So Davido. And what's exciting about Davido and the eChoke token that he's just dropped is the underlying reason why he's doing that. And I'm going to share with you a short synopsis of what he had to say about that. He says, every day, millions of fans create value that is captured by a few execs in a boardroom. Not anymore. We're giving the power back to the fans. I built this with BitSeeker, Africa's new crypto company, Omgate or Omegoat on the Binance Smart Chain. And make sure to follow them. The tokens will give you free access to giveaways, NFTs. And in the spirit of democracy, we will not be selling the tokens to the public. We will release the tokens to the fans through periodic giveaways throughout the next 12 months. I think that's just fantastic. The first giveaway is scheduled for November 28th. And check out Omegoat for details. So that's really good. I mean, we haven't really seen, there's been MI and I think a few artists in the creative art world sector, but we haven't MI being a musician, and then everybody else has been more in the actual art world. But I don't think we've really seen another musician with the kind of clout that Davido has jump into the crypto world and just in general, the digital NFT world. And I think that it's just really, really says a lot and is a game changer for a lot of players in that space, particularly African artists and creatives. So a very interesting thing ahead. Let's see what happens with that. In terms of cryptocurrency, if you're wondering what it is, it's a digital currency used to buy goods and services. The currency is issued as a token. Last week, I was talking about NFTs, defining what they are when we looked at the Tarantino case. So this week, we're talking just generally stepping back about just cryptocurrency as a whole. And then crypto, just like we saw with the NFTs, uses a digital ledger, the blockchain, with strong secure communications technology to secure the online transaction. So again, game changer. We'll see what happens down the line and with what Davido is going to be trying to do with his cryptocurrency. So thank you so much for that particular story, Davido. I'm excited to see what will be happening. I noticed that overall mainstream Nigerian press and other media didn't necessarily cover it. The story was more within the tech industry and tech community and tech news, notwithstanding a very important story that I wanted to make sure that we cover. All right, so the next story I want to cover is BTS. The South Korean group was BTS snubbed for the Grammys in the main categories. There's the BTS, and then we're going to also talk about Wizkid as well, because that's been a big, big, big story. So was BTS snubbed? And here's BTS. All right, so that is BTS, and specifically, what are the accomplishments and why did they not get into the major categories that would expect them to get into Record of the Year, Song of the Year, Album of the Year, Artist of the Year? Their fans are arguing that should have happened, and not only their fans, mainstream American media, global media is saying the same thing, and just everyone thought that they would be in those main categories. So what happened? So here's what we know about BTS with their song, their hit single "Butter." It topped Billboard 10 charts for 10 weeks. It won 3 awards at the 2021 American Music Awards, which was just recently held. It won 4 awards at the 2021 Billboard Music Awards. It also won biggest song debut in Spotify's global chart history. And I think even for the particular BTS performance for its award for the American Music Awards. Actually, no, let's go with the Billboard awards that it won. In the Billboard category, it won top selling song, top song sales artist, top duo/group, and top social artist. For the American Music Awards, it won Artist of the Year, favorite pop song, favorite pop duo /group. Nonetheless, when it comes to the Grammys, they're nowhere to be found except the pop duo group, that the best pop duo/group performance. So what happened there? And we'll see some of what the Grammy folks are saying and go from there. So we have the same issue with Wizkid, right? So let's go to Wizkid. Essence being the biggest song ever. So Essence being a big song featuring Thames, an emerging artist out of Nigeria. Wizkid, a huge Afrobeats artist out of the continent, Nigeria as well. All of the songwriters on that are African, and the song has just historically made such inroads. So why didn't it at least show for, song of the year or record of the year? Fans are asking also. So Wizkid Essence was number 9 on the US Billboard Top 100. It was also number 28 on the Billboard Global 200. It was number 3 on Billboard's US Hot R&B Hip Hop Songs. It was number 21 on Billboard's US Mainstream Top 40, and it was number 11 on US Rolling Stone Top 100, among other things. It's accomplished so many accomplishments. So why is it that it was not also on this, competing in the categories of, Song of the Year, Album of the Year, Artist of the Year, and Record of the Year? Why isn't that happening? And so the response so far so good from the Grammy folks are that it's about the process. So in terms of how the process works, Recording Academy members and record companies enter recordings and music videos released during the eligibility year, which they consider worthy of recognition in the Grammy Awards process. And for the first time in 27 years, the final Grammy nominations were decided only by the Grammy voting members without being subjected to the review committee. So if that's the case, then obviously the question becomes, well, do the voting members know what they're doing? And is the organization does it have such diversity and inclusion where whatever voting results are made, it's not ostracizing people who should be winning these categories when mainstream is saying they should win? And we're seeing, the industry trade publications, the industry awards, industry heads saying this is the kind of album based on data, or kind of song based on data, based on both qualitative and quantitative data, should be winning. Why is it not winning? And so with respect to that particular question, CEO of the Grammys right now, so Harvey Mason Jr., who's the president and CEO, has this to say regarding that. He's been doing a few press rounds addressing those kinds of issues, including the Wizkid situation. So he was saying, as to the committee and his confidence that they would make, not the committee, as to the voting members and his confidence that they would make the right decision. He says, I wasn't nervous. I felt like we've done a lot of important work on our membership. We've done a lot of outreach into different communities that we felt were maybe underrepresented in our voting. So I felt like the timing was right for our membership to be able to directly decide who the nominees were. And he goes on to say, that's why we felt good with removing the nominations review committees at the time that we did. So that's their response. Basically, we've done all the things we need to do internally. We've vetted, we've tried to make sure we have true, full representation. We removed the nominating committee, and we just kept it at our members, trusting that our members, based on the representation of diversity, are able to make the right decision. So check this out. Feel free to leave a comment to tell me whether you agree with that, or if you watch this later on the replay, feel free to do so. If you watch it, if you listen to it via podcast, send a message, DM us through social media channels, or just email us directly and let us know what you think, whether you believe that that is the right result, or if they still need to go and work a lot harder with the voting members in terms of diverse representation, so that what is being voted on matches what we see in mainstream. Or is it a good thing that it's not matching mainstream, and maybe it actually is a truer representation of what who should be winning or not winning? So that's the question, and I look forward to what you have to say about that. All right, we'll take a quick break. When we come back, I want to wrap it up with talking about the Khloe Kardashian case and taking it from there. Actually, before I do, let me see here. I think there are two more things that I want to just highlight with the voting process. And all of this can be found on the Grammys.com website, where they show you what the voting process is. And in addition, they even have an attached document that they have that they show you that they have all their nominees agreed to, which essentially says, yes, you might win this Grammys, but you're just possessing it. You don't own the Grammys. I'm going to give it to you. Actually, you have to just basically, it's in your custody, but you can't resell it. You can't do all these different things to it. So the process begins with members and record companies submitting entries, which are then screened for eligibility and category placement. The Academy's voting members are all involved in the creative, and it continues in the creative and technical process of recording, then participate in the nominating process that determines the 5 finalists in each category, and to the final voting process, among other things that they talk about. So they're saying we've done what we need to do. We've thoroughly vetted internally, and we feel confident that whatever the result is to our voting members is what it is. So, and again, for the first time in 27 years, they decided to get rid of the review committees, which is why the result is what it is. At least that's what they're claiming. So we'll take a quick break. When we come back, we will wrap it up with the Khloe Kardashian case. And specifically, you've got the Allo Photography company suing Khloe Kardashian's Good American for copyright infringement when she posted on her Instagram page a photo of Bella Hadid, a fellow model, wearing her jeans, her Good American jeans. So we'll come back and talk about that and how we're seeing a lot of this type of cases come up over and over again. And if you're an influencer or a company, it doesn't matter whether you're a business, individual, or a personality brand, how you need to tune into the realities of those lawsuits that have been filed a lot by photographers when you're using their work without compensation. And then there's the other question of, okay, how do we deal with the right of publicity issue if your image and likeness are being used in that process as well? So we'll be right back. Let's take a quick break and come back and continue with our discussion. We'll be right back. All right, welcome back, everyone. So this is our final round. If you're just joining us, we covered the Rima versus DJ Neptune case. And then we went on to talk about Davido entering the cryptocurrency world and what he's trying to do with his e-choke social token for fans, the impact he's trying to make to put power back in the hands of fans. And then we went on to talk about whether indeed the allegations by fans when it comes to BTS, one of the top South Korean pop group, and also on the African side, Wizkid and his fans alleging for his song Essence that both records for both bands, right? So on the BTS side, we have Butter, and which is a major record that we've all heard that has done remarkably well, and I laid down all of the facts about how great that record has done. And on the Wizkid end too, how great the record is done. And yet both of them are not represented in the main categories or general categories we would expect them to. Industry heads have said they were supposed to be there. Mainstream American and global media said the same thing. And also with the numbers back that up. So what's the problem? And we looked at how the Grammys is restructuring their voting process and taking it from it being with the committees or subject to the committee's review in the final say, and instead just leaving it exclusively at the hands of their voting members. And then the question was, well, if you do that, are your voting members truly diverse enough to reflect that diversity in the ultimate decision making they make about who should be nominated and not? And the conclusion, according to the president of the organization, Harvey Mason Jr., is yes, they are, because we've done a lot of reaching out and really, really making sure our organization looks very diverse than what we used to have previously, which is why for the first time in 27 years, we've gotten rid of the committees and just left it with our voting members. So that's what we've been talking about so far. The final thing we're covering is a very interesting case that keeps coming up, and I think we'll continue to see this case a lot more as online influencers continue to grow in terms of clout, in terms of working with a lot of major brands, and also brands continue to find themselves in trouble with this particular situation. So the final case that we are talking about is the Aloe Photography versus Khloe Kardashian's Good American Company. And the allegation is for copyright infringement. And this is Khloe Kardashian. And particularly in her jeans, rocking her jeans. I didn't put the photo in controversy, although since we're a media company and under the copyright law in the US, there is the exception with respect to fair use, and exception for newsworthy related stories or criticism of a story, among all, or stories being used for educational purposes, which would all fit here, but didn't really see the need to get into that discussion with respect to that. But focused on this, Aloe Photography says, look, Khloe Kardashian, you went on your Instagram page and you posted a photo that we shot of Bella Hadid, a fellow model, in 2017. And when you posted that, essentially you had a lot of people basically like or get into the photos, and we believe that that helped increase your revenue, increased your profit. The problem is you used the photos without our permission. So you did not get the requisite consent for you to use the photo. Therefore, we're asking you to take it down, an injunction, seek an injunction from the court. We're asking you for any profits that you made off of that should be going to us. And we're also obviously asking you for any other actual damages that we've suffered as a result of you using the work, among other things. So that is what is alleged, and that's what's going on here. Now, typically, what we've been seeing with this particular case is, although this one differs, and one could argue that there's a stronger case on the part of the photography here, much stronger case than what we've seen. But what we've been seeing, which so far so good, photographers have been able to settle the matter or have courts rule in their favor, is I'm a former fashion model turned lawyer. So let's say I go to, let's say I'm a major personality, or even if I'm not, I go to an event and a photographer takes a picture of me. And then I take that picture that is now floating all over the internet and put it on my Instagram page and say, hey, I was at the red carpet of, let's say, the Oscars, and this photo was taken of me, and I'm rocking whatever the designer is that I'm rocking. Now, that photographer, the kind of cases we've been seeing so far so good, that photographer can come and sue me saying, excuse me, you're infringing on my copyright. You never had permission to, in the first place, use my work. Now, that is, when we're talking copyright infringement on that level, we're talking on the federal level. What's happening on the state side, though, is the state also gives you what's called the right of publicity. Different states in the US, that is. Or if you're overseas, maybe you're looking at right of privacy or passing off laws type of, legal statutes that cover that, or statutes that cover that. So on the right of publicity, and in right of publicity states, you essentially can't use people's image, likeness, voice, etc., without their permission. So you, the model, can argue, excuse me, yeah, but you took my image without my permission, and you have it all over the place, and you're making money off it. So what is it to you if I just post up my image of myself that you took? Well, in the final analysis, the federal copyright law trumps the state law for your right of publicity. So we've seen this tension that's been happening over and over again. And a lot of celebrities, including Khloe Kardashian in the past, that have been sued for purposes of this right of publicity violation generally. I mean, sorry, copyright infringement violation, and then they're having to contend and say, oh, well, but I have a right of publicity, and since I have a right of publicity, you should not be suing me. Or even if you can, isn't it morally wrong for you to do so? This case is very interesting because it's a little different. This case is clearer on the copyright infringement. For this particular case, you have a scenario where a company or company CEO goes on social media and is sharing an image of somebody else. This is not an image of herself, of someone else, a fellow model wearing her clothing, taken by a different photographer. I mean, taken by a photographer. So technically speaking, there's a strong case to be argued. Not technically speaking, there is a strong case to be made. That is someone else's work. You should get consent if you're going to use the work, especially using it in the commercial sense that you are using it. Because if you do have the image on social media and you are Khloe Kardashian, probability is most people are going to go buy that jeans. So if they're going to, because of the image that was taken, then you should be compensating. So that's what we have going on here. Interesting case. I do expect or see that they will try to resolve it through a settlement. But let's see what happens. I don't see it necessarily going too far. If it was the other scenario that I talked about initially, celebs were quick to try to settle this, but now a lot of them are starting to push back. The other scenario where it's an image of me, you're a photographer, you sued me, and you're telling me that I can't, use your image. You're now seeing celebrities push back, some doing the right of publicity, trying to make a right of publicity argument violation and countersuing, among other things, in a different, intriguing way. But we've really not seen that particular type of scenario come to fruition in terms of what the courts have said, because we haven't really seen it litigated out. But in future, I do expect that the litigation, the trial and related issues will be around there. So that is what we've been talking about, and we're pretty much getting ready to wrap it up. I see a comment here from William. William, thanks for watching. He says, what are your thoughts on amending the copyright laws, seeing that everyone has access to a camera? If it's a trademark brand / celebrity is featured in a photo, share the copyright. If it's a trademark brand / celebrity is featured in a photo, share the copyright. I'm not sure I understand that particular part. But in terms of amending the copyright laws, that's an interesting one. I don't know that we need to per se. That's an interesting question, William. I'm not sure that we need to amend the copyright law per se for the infringement of the photo, infringement of a photo. And I don't think the issue is that everyone has access to a camera. That's not the issue here. The issue here is that because everyone having access, not everyone has access to where celebrities are. Those red carpet events or major events, not everyone has access to take those images. And even if they did, celebs don't go around generally just putting up images of the regular person who took them on the street. And generally, people don't have access to that. So the key issue is when a professional photographer takes an image of you in a public setting and you're a public figure, do you have any rights whatsoever to fight back? And I think the copyright law already covers for the protection of that photographer or anyone who takes an image immediately. That bundle of right is given to you. You have ownership of that exclusive work that you've created. However, I think what I would like to see is a beefing up more of that that right of publicity law, where it still has a little bit more bite. And I think, I certainly would find a way somehow consider, I didn't give you permission, but you're a public figure, which changes the analysis and the commercial of the right of publicity. But if it wasn't that publicity, the right of publicity, public figure side of things, generally you need a release if you are going to just take someone's picture, even if you're a photographer. That's why for models, photographers always get the releases, because you can't just use people's images without their permission. It starts getting very interesting when we're talking about celebs. You heard where the subject of the photos share copyright in the photos. Okay, in what scenario? Because this scenario doesn't necessarily apply. So if two people share copyright in the photos, then there's no need to amend the copyright law, because the copyright law already provides for what that happens. If it's not explicitly delineated, then the default is you both have, equal ownership in that photo. So on a 50-50 ownership of the photo. So there is no reason then to amend the copyright law for that. So hopefully that answers your question. All right, so I think we've covered basically all of the key things I wanted to cover today. Excuse me. Thank you for joining me. And again, if you are just joining, it was a very short and sweet to the point coverage, focusing on some of the key stories I wanted to cover: alleged copyright infringement, or unauthorized release of music by an artist from the continent making strides globally. Major global artist, Afrobeats artist Davido getting into the crypto world. BTS and Wizkid, BTS South Korean pop band, Harvard case study, among other things, allegedly being snubbed with a Grammy nomination. They got nomination for Best Duo Pop Group, but not for the categories of Record of the Year, Song of the Year. We thought they would. Wizkid, similar thing, Best Global Performance and Best Global Album, but not what we thought: Record of the Year, Song of the Year, etc. So that's been an issue among fans, taking it up, etc. And then finally, we wrapped it up with the Khloe Kardashian case, and a very interesting case there as well. So thank you for joining us. I will see you next week. The plan is still to continue with this. About mid-December, we'll take annual break and then pick up next year in early January as we continue with the podcast. The podcast will continue. There will be several changes that we're going to make with respect to the brand and expand services and offerings that we have. But for the core podcast, we certainly will continue. So thanks for joining us. Thank you, William, for your comments and your questions. Appreciate it. Take care, everyone. Have a good one. We'll see you very, very, very soon. Let's get this going on the goodbye. Cheers.